Dear Nordic colleagues, my presentation is a story about two ECL initiatives that failed. The intention is not to spoil the party at the last minute, but rather to take a look at the flip side of the coin. During the past 2 days, much has been said about the relation of EU law towards the Nordic ECL as it is. My approach is the opposite. How does the European Commission understand ECL as a tool for its own purposes? I will try to find some answers by exploring impact assessment documents relating to two recent initiatives, Orphan Works and online licensing of music. In both cases, the European Commission first considered ECL as a possible solution to complex cross-border problems, but at later stages rejected this alternative. My question is why? Were the reasons same in both cases? Did they relate to the basic structures of ECL or rather to its applicability in certain conditions? What conclusions can we draw from these two failures with a view to future cases? To be able to bring out the key problems for examination, I will first have to do a brief recap on both cases. And we'll start with Orphan Works. Orphan Works case dates back to year 2005 and the Commission's ambition of creating Europeana, a pan-European digital library and archive. After some further studies, the Commission finally in 2010 set out to conduct an impact assessment. By this time, things had developed in the United States, where the Google book settlement of 2008 seemed to improve the legal framework for large-scale digitization of copyright-protected material. Therefore, the emphasis of the Orphan Works initiative shifted from cultural goals towards facilitating text and data mining in Europe. The Commission concluded that new rules that would enable prior authorization for accessing Orphan Works online would have to be adopted. The legal problem as such was a basic one. Libraries need prior authorization from right holders before they can make works available online. The practical problem was that those right holders cannot always be reached, but bypassing their consent may have serious negative consequences. The Commission first defines some basic concepts. An orphan work is one whose rights holders cannot be identified or traced even after a diligent search has been carried out. A diligent search is a procedure where the library must consult designated databases or other sources of information before a work can be treated as orphan. Mutual recognition is a commitment between member states that the work that has been confirmed as orphan in one member state will have the same status in other member states. The Commission then explored 5 different policy options, of which ECL was one. Extended collective management was described as being a system where a collecting society is given a mandate to represent the interests of all right holders of a certain category, even if they are not formally registered with that society. The Commission first listed the positive sides. In an ECL system, no diligent search would be necessary and the license would cover all right holders and all their works. The law would provide legal indemnity against third-party claims and right holders would still have a right to opt out from the scheme. But there were several drawbacks too. The main disadvantage of ECL was that because there would be no diligent search, there would be no legal certainty at any given stage as to how many works in a given licensing arrangement are actually orphan works. Without a diligent search, a mutual recognition of confirmed orphan works would not be possible either. Libraries would need to conclude many contracts regarding different types of works, and the ECL effect would be limited to the territory of one member state only. In addition, by using the Norwegian Bokhylla tariff as a basis for calculation, the Commission concluded that the licenses would be way too expensive. Finally, the ECL would generate a lot of new red tape in member states. I will come back to these arguments later. In the Commission's final evaluation, ECL did not score very well. In fact, it was placed last, while the mutual recognition option was declared winner. My second case, multi-territorial licensing, has a prehistory reaching to year 2004. In the communication on the management of copyright in the internal market, the Commission indicated that it had plans for harmonizing European collective management. In 2005, the Commission published a recommendation addressed to the market players that were active in cross-border licensing of music online services. The Commission urged the parties to develop innovative licensing solutions and to break up established patterns. Indeed, during the next couple of years, the biggest music publishers withdrew their online rights from collective management and started to license them directly or through new entities. Further, in 2006, DG Competition launched an antitrust investigation which involved all European societies managing musical copyrights. Finally, in 2011, the Commission started to pull the strings together in the Single Market Act, where the idea of online licenses covering the whole of the EU was launched. In the 2012 impact assessment for the CRM directive, the Commission stated that it had detected technical and procedural flaws in the operations of many CMOs, meaning that these organizations were not fit for cross-border online licensing. But there was also legal uncertainty surrounding the licensing of multi-territorial web services. The Commission explained that several patterns had been deployed for cross-border licensing. Some CMOs granted mono-repertoire licenses on a multi-territorial basis, which was also the prevailing mode of licensing for Anglo-American publishers. The rest of the CMOs took care of the remaining rights they were mandated to manage, in other words, granted multi-repertoire licenses on a mono-territory basis. Again, the Commission contemplated several policy options, ECL as one of them. This time, the description was more elaborate, containing two key elements. First, a representative CMO in any member state would be mandated to license the entire repertoire of musical works. And secondly, such a license would cover the entire EU territory, so that rights would have to be cleared only once in one member state. The Commission's arguments in favor of ECL were the following. At first glance, it seemed to provide legal certainty because the license covers the entire EU. In addition, right holders would remain free to license individually too. An ECL-based solution would generate some competition in collective management because service providers could obtain licenses for the same repertoire from all CMOs. Further, all repertoires would be represented, also those with less commercial attractivity. And finally, small and medium-sized national CMOs would still have a role to play in their home markets. But the list of drawbacks was much longer. ECL would not generate incentives to identify repertoires accurately, and therefore inefficiencies of internal management procedures that the Commission had observed would not be corrected. This would in turn result in the exodus of the biggest right holders with the most valuable repertoires. Therefore, the total coverage of rights in collective management would fall, which from the service provider's perspective would mean that more licenses would have to be obtained from a growing number of licensors. The Commission also wondered if an individual right holder in real life could exercise control over non-domestic CMOs or perform an opt-out from collective management on a EU-wide scale, and concluded that the chances were slim. There were other items on the list too, but I will skip them here. No wonder then that ECL did not make the grade in the Commission's review, as you can see. The European licensing passport was the chosen option. And now it's time for some reflection and conclusions. First, It seems that under the common heading Extended Collective License, the Commission was trying to solve problems of two different kinds. With orphan works, the problem was the unknown identity or whereabouts of the right holder and how to establish a cross-border recognition of, so to speak, the non-findings of such right holders. In this case, the Commission was not pursuing a cross-border licensing effect, but a cross-border registration effect that would facilitate national exploitation of orphan works. From the Nordic perspective, the tool was wrong. The extension effect covers also, and perhaps mainly, right holders who are not known either to the licensing CMO or to the licensee. In other words, the validity of ECL is not subject to prior identification of non-represented right holders or works. This is one of the cornerstones of ECL. Therefore, no registration of non-represented right holders or works is necessary. But this was just what the Commission was looking for and did not find in ECL. In multi-territorial licensing, the problem did not relate to right holders' identities, but rather to the availability of their repertoires. The purpose of multi-territorial licensing under ECL would have been to gather all repertoires under one license with a full EU-wide cross-border effect. But to do this 27 times and to have a European single market full of overlapping licenses covering all musical works, the right holders known or unknown. No wonder the Commission did not consider this a good idea. This points to another fundamental of the Nordic ECL, the national scope of application. In a system with only one competent licensing body, the extension effect is manageable. But if several organizations have a parallel competence to generate an extension effect that reaches beyond their respective territories of operation, problems can be expected. This might be avoided or at least mitigated if all right holders, all works, and all contractual arrangements would be neatly registered in databases that are available to all interested parties. But they are not. I would like to pick one more item from the Commission's drawback list, and that is opt-outs. Yesterday, Professor Rosen predicted that too many opt-outs will lead into disorder of the system, and in her reference to the Sullier and Doak case, Professor Ginsberg suspected that how the opt-out is structured will matter. I hope that I quoted you both correctly. What happened in the collective management of musical copyrights after the Commission's 2005 recommendation is a showcase of the fragmentation of repertoires caused by withdrawals of rights from collective managements. Large-scale opt-outs alone may not directly lead into disorder of ECL, but they do shake up the market and dilute the extension effect. As to the practical form of opt-out procedures, the Commission had serious doubts whether an individual right holder can invoke this right, not at least in relation to 27 different CMOs. But even in relation to a single CMO, I think this is a question with increasing importance. The spirit of the CRM directive is to give right holders more control over their rights and more opportunities for exercising those rights as they see fit. Opting out from ECL may long have been a rarely utilized alternative in many licensing areas, but this may not be the case anymore in years to come. I think CMOs should be prepared for this and polish up their procedures and services. Finally, some concluding remarks on ECL and the European Commission. On the basis of this examination, it is apparent that the Commission does not feel that it should be bound to the Nordic conception and tradition of ECL. It will rather develop its own interpretations of ECL as necessary, which, to my mind, resembles the treatment of the European Court of Justice has recently given to fundamental concepts of copyright law, such as communication to the public. It also seems that the Commission is bothered by a certain fuzziness of ECL. On the basis of the impact assessments, the Commission appreciates clear and complete records, cost awareness and transparency, high match between money and rights, and policies that are apt to enhance competition and innovation. I think it is also important to note that the Commission's assessments on ECL were not primarily legal, but economic and practical. Does the system work? Under what conditions could it work? What kinds of effects will it have? And finally, because ECL is an attribute of the general collective management, I think it is likely that the Commission will use the CRM directive as a framework and benchmark when taking a stand on future ECL initiatives, be they of Nordic origin or made in Brussels. Thank you very much.